Well, good afternoon everybody. Let's carry on with what is probably going to be the fifth and final part of this look at the decision of Judge William Duffin. This is starting off midway in page 71. He wrote, "Thereafter the details of the shooting emerged or perhaps evolved in a similarly protracted fashion. Initially, Dassey told the investigators that Avery shot Holbach twice. Then it was 3 times. Later, after Fassbender said, 'Remember, we got a number of shell casings that we found in that garage,' Dassey said that Avery shot Holbach about 10 times while she was on the garage floor. Wiegert responded, 'That makes sense. Now we believe you.' Dassey's description of where the shooting took place was also an evolution. He first told the investigators that the shooting occurred outdoors and that Holbach was never in the garage. Then he told them that the shooting occurred in the garage. Specifically, Dassey said Holbach was in the back of her RAV4 when shot, but immediately thereafter he said that she was on the garage floor when she was shot. Finally, only after Fassbender's highly leading questions did Dassey acknowledge that Avery went under the hood of Holbach's RAV4. When Fassbender asked Dassey what else he and Avery did to the RAV4, he could not muster the answer Fassbender was looking for until Fassbender asked, did he go and look at the engine? Did he raise the hood at all or anything like that? Dassey responded affirmatively, but when pressed for additional details, he could offer none. Instead, all he could say was, "I don't know what he did, but I know he went under." The investigators' use of leading questions and disclosure of non-public facts makes it difficult to evaluate whether Dassey really knew the facts or was simply agreeing with the investigators. And he cites a book, Brandon L. Garrett, The Substance of False Confessions. And he also mentions that it was discussed in Richard Leo's testimony, noting that police training materials emphasize that to enable later evaluation of whether a statement was true, interrogators should not provide the suspect with non-public details or ask leading questions on crucial points. Based on its review of the record, the court acknowledges significant doubts as to the reliability of Dassey's confession. Crucial details evolved through repeated leading and suggestive questioning and generally stopped changing only after the investigators, in some manner, indicated to Dassey that he finally gave them the answer they were looking for. Purportedly, corroborative details could have been the product of contamination from other sources, including the investigators' own statements and questioning, or simply logical guesses, rather than actual knowledge of the crime. Courts have long excluded involuntary confessions on the basis that they are inherently unreliable. The Court of Appeals for the Seventh Circuit in Connor versus McBride stated the fact that the petitioner's confession was found to be reliable tended to support the conclusion that the statement was voluntary. The present case represents the flip side of the Connor coin, where the doubts as to the reliability of Dassey's confession would tend to support a finding that the confession was involuntary. The Supreme Court long ago detached the admissibility of a confession from its reliability and made voluntariness alone the benchmark of admissibility. The aim of the requirement of due process is not to exclude presumptively false evidence, but to prevent fundamental unfairness in the use of evidence, whether true or false. Thus, voluntariness is a question to be answered with complete disregard of whether or not petitioner in fact spoke the truth. Accordingly, from a constitutional perspective, if a person voluntarily but falsely confesses, it is the jury, not the court, that serves as the check against an innocent person being convicted of a crime he did not commit. The motion that's before the court today is not directly concerned with the truthfulness or the falsity of the statements given, but rather their voluntariness. By returning verdicts of guilty, the court presumes the jury found Dassey's confession reliable. This court's doubts as to the reliability of Dassey's confession are not relevant considerations in the assessment of whether Dassey's confession was constitutionally voluntary. Section 3. Analysis of Dassey's confession. The court must look at all relevant facts to determine whether Dassey's March 1st confession was voluntary. The interview occurred midday rather than in the early morning hours, or at a time when Dassey might expect to be asleep. The questioning was not particularly prolonged, although Dassey was in the interview room from around 11 a.m. until 4 p.m. The relevant questioning spanned less than 3 hours. Dassey was left alone for less than 2 hours, the longest single stretch being about 50 minutes. He was offered food and beverages. Although the interview occurred at a police station, it was in a soft interview room with carpeting, upholstered furniture, as opposed to a room with an uncarpeted floor, a hard table and chairs. Wiegert advised Dassey of his rights under Miranda, including the right to not answer questions, to stop the questioning, and to have an attorney appointed for him and present during any questioning. Dassey exhibited no signs of agitation or distress throughout the interview. He sobbed only after being told he was under arrest. The investigators maintained calm tones, never using aggressive or confrontational tactics. If these were the only relevant facts, they would tend to support a finding that the March 1st confession was voluntary. But when assessed against all of the circumstances of Dassey's interrogation, these facts are overshadowed by far more consequential facts. For starters, Jack Dassey was a juvenile, only 16 years old at the time of his confession. Also significant is the fact that investigators questioned Dassey without the presence of a parent or other adult looking out for his interests. It is true that neither federal law nor the United States Constitution requires that the police even inform a juvenile's parents that the juvenile is being questioned, or honour a juvenile's request that a parent or other adult, other than a lawyer, be present during questioning. However, because it's easier to overbear the will of a juvenile than a parent or attorney, in marginal cases, when it appears the officers or agent has attempted to take advantage of the suspect's youth or mental shortcomings, lack of parent or legal advice could tip the balance against admission. Not only did Dassey not have the benefit of an adult present to look out for his interests, the investigators exploited the absence of such an adult by repeatedly suggesting that they were looking out for his interests. Quote, "I want to assure you that Mark and I are both in your corner. We're on your side, and I'm your friend right now, but I gotta believe in you, and if I don't believe in you, I can't go bat for you." In the interview just 2 days earlier, on February 27th, 2006, where Dassey was also unaccompanied by an adult, Fassbender went even further. And we've got a lengthy quote. "I've got kids somewhat your age. I'm looking at you and I see you in him and I see him in you. I really do. And I know how that would hurt me too. Mark and I, yeah, we're cops. We're investigators and stuff like that. But I'm not right now. I'm a father that has a kid your age too. I want to be here for you. There's nothing I'd like more than to come over and give you a hug because I know you're hurting." Consistent with this paternalistic approach, Wiegert repeatedly touched Dassey's knee in a compassionate and encouraging manner during the March 1st interview. In one instance, Wiegert put his hand on Dassey's knee, leaned forward and said reassuringly and encouragingly, "We already know, Brendan, we already know. Come on, be honest with us. Be honest with us. We already know. It's okay. We're going to help you through this." All right. He later did this again while saying, "Brendan, I already know. You know we know. Okay? Come on, buddy. Let's get this out. Okay?" Moreover, Dassey's borderline to below average intellectual ability likely made him more susceptible to coercive pressures than a peer of higher intellect. And they quote Henderson, a case called Henderson, where Henderson's purportedly low IQ and limited reading and comprehension capabilities obviously called for caution in assessing an uncancelled waiver of his constitutional rights. And they quote another case, Ruvalcaba versus Chandler, noting as a factor in denying habeas petition the absence of evidence that he was of abnormally low intelligence or otherwise was highly vulnerable. So getting back to Dassey, although he attended regular education classes, Dassey received special education support services. 10 years earlier, his IQ was assessed at an overall score of 74. Testing over time yielded similar results. In addition, prior to the Holbach investigation, Dassey had had no contact with law enforcement. Whereas in another case of Hardaway, the petitioner had 19 previous arrests for charges including robbery, attempted criminal sexual assault, unauthorized use of a weapon and delivery of a controlled substance. Crucial in the voluntariness analysis is what the investigators told Dassey at the beginning of the interrogation. Fassbender assured Dassey, "From what I'm seeing, I'm thinking you're all right, okay? You don't have to worry about things." In isolation, such a statement would not be a problem. Based on what the investigators actually knew at the time, they very possibly believed Dassey to be merely a witness. However, less than 2 minutes later, Wiegert assured Dassey, "We pretty much know everything. That's why we're talking to you again today." The combination of these statements, that the investigators already knew pretty much know everything and that Dassey did not have to worry about things, is an entirely different matter. The investigators were not merely telling Dassey, "Based upon what you have told us so far, we don't think you have anything to worry about." Rather, what they told Dassey was, "We already know what happened and you don't have anything to worry about." The investigators' assertions that they already knew what happened and assurances that Dassey did not have anything to worry about were not confined to an isolated instance at the beginning, but rather persisted throughout the interrogation. Early on, before Dassey had said anything incriminating, Wiegert again told Dassey, "Now remember, this is very important, because we already know what happened that day." "We already know what happened," Fassbender assured Dassey. "I'm your friend right now, but I gotta believe in you. And if I don't believe in you, I can't go back for you." Fassbender continued, "We're in your corner." And Wiegert added, We already know what happened. Now tell us exactly. Less than a minute later, Wiegert again said, we already know. Just tell us, it's okay. The investigators went on to repeat that they already knew what happened at least 24 additional times throughout the interrogation. Wiegert, come on, we already know. We know this already. Be honest. Wiegert, remember, we already know, but we need to hear it from you. Wiegert again. So just be honest. We already know. Again, Wiegert, we already know. Wiegert again. We already know. Be honest. Wiegert again. We already know, Brendan. We already know. Come on, be honest with us. Be honest with us. We already know. It's okay. We're going to help you through this, all right? Wiegert again. It's okay, Brendan. We already know. Fassbender. Because we know, but we need it in your words. I can't say it. Wiegert again. Brendan, I already know. You know we know. Okay? Come on, buddy. Let's get this out. Okay? Wiegert again. Remember, we already know, but we need to hear it from you. It's okay. It's not your fault. Fassbender again. We know. Wiegert again. We know you were back there. Let's get it all out today, and this will all be over with. Wiegert again. We know what happened. Wiegert again. We know what happened. It's okay. Again, Wiegert. You were there when she died, and we know that. Don't start lying now. We know you were there. Wiegert, we already know. Don't lie to us now. Okay, come on. Wiegert, he did something else. We know that. Wiegert, we know he did something else to her. What else did he do to her? Wiegert again. We know something else was done. Tell us. And what else did you do? Fassbender, we know he made you do something else. Fassbender again. We know, we just need you to tell us. Fassbender again. We know there's some things that you're not yet telling us. Fassbender. We know that some things happened in that garage and in the car. We know that. Wiegert. We know you shot her too. The record indicates that these false assertions had a powerful effect upon Dassey. Even the respondent acknowledges that the most jumped a little bit there. The record indicates that these false assertions had a powerful effect upon Dassey. Even the respondent acknowledges that the most damaging admissions Dassey made in his interview were all made as investigators encouraged Dassey to tell the truth because they already knew what had happened. At the same time, the investigators were telling Dassey that they already knew what happened. They frequently reassured him that he did not have anything to worry about. After Fassbender assured Dassey that, from what I'm seeing, I'm thinking you're all right, okay, you don't have to worry about things. At least 4 separate times, Wiegert returned to his theme when he told Dassey, it's okay, while saying they already knew the details Dassey was not telling them. Many other times, removed from assertions that the investigators already knew what happened, the investigators repeatedly suggested to Dassey that he had nothing to worry about. Wiegert, no matter what you did, we can work through that. Wiegert again, it's okay as long as you can, as long as you be honest with us, it's okay. If you lie about it, it's going to be problems, okay? Wiegert again. It's okay. Wiegert, it's okay. Tell us what happened. Wiegert, it's okay. Again, it's okay what you did with it. Wiegert, Brendan, it's okay to tell us. Wiegert, what about the knife? Where is the knife? Be honest with me. Where's the knife? It's okay. We need to get that, okay? Help us out. Where's the knife? In one instance, when asking Dassey if he helped Avery put Halbach in the back of her RAV4, Wiegert explicitly assured Dassey, if you helped him, it's okay because he was telling you to do it. Similarly, just before Dassey stated that he cut Halbach's throat, Wiegert prompted Dassey by telling him, it's okay, what did he make you do? In another instance, Wiegert told Dassey not only that it's okay, he assured Dassey, it's not your fault. Wiegert separately assured Dassey that once he told them everything that they already purportedly knew, this will all be over with. Wiegert also told Dassey that honesty is the only thing that will set you free. Granted, that statement is just an idiom. See Book of John 8:32. And you will know the truth, and the truth will make you free. And routinely understood not to be taken literally. With respect to possible coercion, the court found the detective's comment, "The truth will set you free," was a general statement about relieving one's conscience, rather than a promise of freedom. State versus Osborne, 2002. The court interprets "the truth will set you free" to mean that telling the truth will ease the defendant's conscience. And in another case, "the truth shall set you free" statement, although questionable, amounts to nothing more than encouragement to tell the truth. And in this Edwards versus the state, surely Edwards did not think the truth would literally set him free. The investigators simply were appealing to Edwards' religious background in encourage him not to lie. However, some courts have criticised its use by interrogators, Morgan versus State, and especially relevant here. Testing revealed that idioms were an aspect of abstract language that Dassey had difficulty understanding. Dassey's conduct during the interrogation and his reaction to being told he was under arrest clearly indicate that he really did believe that if he told the investigators what they professed to already know, he would not be arrested for what he said. In another case, Sharp versus Rowling, Miss Sharp's surprised and angry reaction when Detective Wheels arrested her at the end of the interview indicated her incriminating statements were not the product of free will because they were given on the false promise she would not go to jail. After admitting to committing exceptionally serious crimes, Dassey twice expressed his expectation that he would be allowed to return to school that day. And at the end of the interrogation, when asked what he thought should happen, there is absolutely no indication that Dassey anticipated that he would be arrested. Even after being told he was under arrest, he did not seem to grasp the seriousness of the matter, asking, "Is it only for one day?" The investigators' statements were not merely ambiguous promises to Dassey that cooperating would lead to a better deal or that the investigators would stand behind him or go bat for him. Although they said those things as well, rather the investigators' collective statements throughout the interrogation clearly led Dassey to believe that he would not be punished for telling them the incriminating details they professed to already know. While at one point Wiegert did rotely say, "We can't make any promises," this single isolated statement was drowned out by the host of assurances that they already knew what happened and that Dassey had nothing to worry about. Thus, the state court's finding that there were no promises of leniency was against the clear and convincing weight of the evidence. Concluding that the investigators never made any such promises was no minor error, but rather a fact that was central to the court's voluntariness finding. In O'Quinn versus Spiller, holding that minor factual errors do not merit habeas relief unless the petitioner can show that the state court's decision was based on that factual error. Given the other facts that tend to support the conclusion that Dassey's confession was involuntary, as discussed above, this unreasonable determination of fact was undoubtedly crucial in the court's ultimate decision that Dassey's confession was voluntary. A state court decision that rests upon a determination of fact that lies against the clear weight of the evidence is, by definition, a decision so inadequately supported by the record as to be arbitrary and therefore objectively unreasonable. Because the trial court based its decision on an unreasonable factual determination, the substantive merits of the petitioner's claims are analysed under the pre-EDPA standard. that is de novo, because there is no state court analysis to apply EDPA standards to. As discussed below, the court finds that the Court of Appeal's decision was not merely incorrect, it was unreasonable. Thus, Dassey satisfies the lower de novo review standard required for relief. Consequently, Dassey is entitled to relief by way of 28 US Supreme Court, and see another case, Sharp, granting petition for the writ of habeas corpus under section 28 because state court unreasonably found that the interrogators did not make any promises of leniency to the petitioner. Carrying on, the court also finds that independent of the state court's unreasonable factual determination and Dassey's entitlement to relief under the de novo standard of review by way of USC 28, Dassey is separately entitled to relief under US Supreme Court 28, 2254 D1. The Court of Appeal's factual error is itself relevant in assessing the reasonableness of its ultimate conclusion. See Pohl versus Randolph, Wiggins v. Smith. More than merely disagreeing with the Court of Appeal's decision or concluding that it would have reached a different decision if it had been the state court, the court finds that the state court's decision was an unreasonable application of clearly established federal law as set forth in many decisions of the United States Supreme Court, including Miller versus Fenton, reiterating that the Supreme Court has long held that involuntary statements are not admissible, and Arizona versus Fulminante, holding in part that psychological pressure may render a confession involuntary. The primary error in the Court of Appeal's terse decision was its focus on facts in isolation and its failure to assess voluntariness under the totality of circumstances. Although the Court of Appeals correctly noted the totality of the circumstances standard, its decision does not reflect its application. For example, omitted from its discussion is any consideration of how the absence of a parent or allied adult affected the voluntariness of Dassey's confession. Nor does the Court of Appeal's decision reflect any consideration of how the investigators overcame Dassey's resistance by deliberately exploiting the absence of his mother, feigning paternalistic concern for his best interests, and by statements such as, "Your mum said you'd be honest with us." Granted, state courts are not required to address every jot and tittle of proof suggested to them, nor need they make detailed findings addressing all the evidence before them. However, if the overlooked fact was highly probative and central to the petitioner's claim, the state court's omission will fatally undermine its fact-finding process and render the resulting finding unreasonable. The absence of Dassey's mother, especially when considered in conjunction with evidence of how the investigators deliberately exploited her absence, is a fact highly probative of Dassey's claim, such that its absence from the Court of Appeal's analysis undermines its conclusion. Most significantly, however, the Court of Appeals erred when it focused on the statements of the investigators in isolation to conclude that they did not make any promises of leniency. True, no single statement by the investigators, if viewed in isolation, rendered Dassey's statement involuntary, but when assessed collectively and cumulatively, as voluntariness must be assessed, it is clear how the investigators' actions amounted to deceptive interrogation tactics that overbore Dassey's free will. The Supreme Court has long recognized that a false promise is a powerful force in overcoming a person's free will. A confession in order to be admissible must be free and voluntary. That is, must not be extracted by any sort of threats or violence, nor obtained by any direct or implied promises, however slight, nor by the exertion of any improper influences. Consequently, a false promise of lenience is an example of forbidden interrogation tactics, for it would impede the suspect in making an informed choice as to whether he was better off confessing or clamming up. More than merely assuring Dassey that he would not be punished if he admitted participating in the offences, the investigators suggested to Dassey that he would be punished if he did not tell the truth. However, because the investigation's assertions that they already knew what happened were often false, the truth to the investigators was often merely whichever of Dassey's version of events they eventually accepted. Thus, as long as Dassey told a version the investigators accepted as the truth, he was led to believe he had no fear of negative consequences. But if the investigators did not accept as true the story Dassey told them, he was told there would be repercussions, especially when the investigators' promises, assurance and threats of negative consequences are assessed in conjunction with Dassey's age, intellectual deficits, lack of experience in dealing with the police, the absence of a parent, and other relevant personal characteristics. The free will of a reasonable person in Dassey's position would have been overborne. Once considered in this proper light, the conclusion that Dassey's statement was involuntary under the totality of the circumstances is not one about which fair-minded jurists would disagree. Consequently, the court finds that the confession Dassey gave to the police on March the 1st, 2006 was so clearly involuntary in a constitutional sense that the Court of Appeal's decision to the contrary was an unreasonable application of clearly established federal law. The court does not reach this conclusion lightly. The present decision is made in full appreciation of the limited nature of the habeas remedy under AEDPA, and mindful of the principles of comity and federalism that restrain federal intervention in this arena. However, the high standard imposed by AEDPA is not a complete bar to relief. While the circumstances for relief may be rare, even extraordinary, it is the conclusion of the court that this case represents the sort of extreme malfunction in the state criminal justice system that federal habeas corpus relief exists to correct. That said, the court does not ascribe any ill motive to the investigators, rather than an intentional and concerted effort to trick Dassey into confessing. What occurred here may have been the product of the investigators failing to appreciate how combining statements that they already knew everything that happened with assurances that Dassey was okay and had nothing to worry about collectively resulted in constitutionally impermissible promises. Thus, the court turns to the final obstacle of obtaining habeas relief, whether the admission of the involuntary confession was harmless. Specifically, the court must decide whether the admission of a confession obtained in violation of Dassey's constitutional rights had substantial and injuring effect or influence in determining the jury's verdict. A confession is like no other evidence. Indeed, the defendant's own confession is probably the most probative and damaging evidence that can be admitted against him. A confession can be so decisive and so profoundly prejudicial in the adversarial process as to make the other aspects of a trial in court superfluous. Having thoroughly reviewed the trial transcript, the court has no difficulty concluding that the admission of Dassey's confession was not a harmless error. Dassey's confession was, as a practical matter, the entirety of the case against him on each of the 3 counts. Conclusion. Although Kaczynski's misconduct was indefensible, the United States Supreme Court has never accepted arguments such as those Dassey makes here as a basis for relief under Sullivan. Therefore, federal law prohibits the court from granting Dassey habeas relief on the first claim he presented to this court. However, the state courts unreasonably found that the investigators never made Dassey any promises during the March 1st interrogation. The investigators repeatedly claimed to already know what happened on October 31st and reassured Dassey that he had nothing to worry about. These repeated false promises, when considered in conjunction with all relevant factors, most especially Dassey's age, intellectual deficits, and the absence of a supportive adult, rendered Dassey's confession involuntary under the 5th and 14th Amendments. The Wisconsin Court of Appeals decision, to the contrary, was an unreasonable application of clearly established federal law. It is therefore ordered that Brendan Dassey's petition for a writ of habeas corpus is granted. The respondent shall release Dassey from custody unless, within 90 days of the date of this decision, the state initiates proceedings to retry him. And of course, we know what happened within an hour or 2 of Dassey being released. He'd already cleared his cell and given away most of his stuff. They decided to wait to the very last minute to call for the en banc hearing, which is so very, very rarely given. And then, of course, at the en banc hearing, we had judges drop out, 2 judges drop out, and eventually the decision was 4-3 against Brendan. We all know about that. But I do find that whole article, that whole decision by Judge Duffin very interesting. He's taken a lot of time. He did take a lot of time to consider. I think the decision was something like 2 years after he first started work on the confession by Brendan Dassey. So I certainly congratulate Judge William Duffin. I thought that was an excellent appraisal, maybe at times slightly lenient towards Wiegert and Fassbender and the state, but nonetheless, and Kaczynski and O'Kelly, but nonetheless, it was the right decision and should have been upheld. And one wonders, don't we, whether the fact that Making a Murderer, the Netflix documentary, came out, that was August time. So Netflix released Making a Murderer just 7 months previous to that decision. One wonders if that is one of the reasons why the state decided to appeal to the 7th en banc. Whether if it hadn't, maybe if it hadn't been for Making a Murderer being released, it would have just been accepted and Brendan would have been let out. We'll wait and see. We'll wait and see what happens. It's not long now, I believe, till I believe it's the 11th of February when we get the reply from the state to Kathleen Zellner's latest motion. So anyway, hope you enjoyed listening to all 5 parts of that decision by Judge Duffin. As I say, I thought it was an excellent review. No doubt you will let us know what you think about it as well in the comment section. Anyway, if I don't see you before the new year, have a good new year, and we'll catch you again soon. Bye for now.